everyone, I am 𝓥𝓲𝓫𝓱𝓪 and welcome to 𝓥𝓲𝓫𝓱𝓪𝓷. In this video, I'll explain the chapter 2nd of class 11th political science. The chapter that we have got for this video is Rights in the Indian Constitution. So rights in the Indian Constitution. Now this chapter is basically about the fundamental rights given to us and that are written in the Constitution of India. Now this chapter becomes very important as it says about the fundamental rights that you will have to study even after graduation if you're looking for in some big books like 𝓥𝓲𝓫𝓱𝓪𝓷 too, which I have made a video of too. Now, in this chapter, we will talk about the rights that are given to the citizens. As we have already seen that the Constitution is not just about the composition of the government and the levels of government. In the previous chapter, we did see that there are certain limits on the government, on the powers of the government, and certain rights are being enjoyed by the citizens of India. Those rights are the fundamental rights given to us by the Constitution of India. So basically we'll talk about the fundamental rights in this chapter. Now after studying this chapter, you would get the answers of these questions. First of all, what are the fundamental rights? What are the various fundamental rights that are written in the Constitution of India? Secondly, what role the judiciary plays in protecting these rights, because we do need something or someone to guarantee the protection of these rights. Thirdly, the difference between the fundamental rights and the directive principles of state policy. Over the 6 decades that these rights have been given, there have been many amendments in them and there have been change of scope as well, but somewhat it has been expanded. So we will try to see at different perspectives of fundamental rights. Firstly, try to look at why we need that and what are the importance of it. Then we will discuss about particular fundamental rights that are in the Constitution of India. So without any further ado, let's get started with the first topic, that is the importance of rights. So the importance of rights. Now first of all, why do we even need a right? Is there really a need of right in our life? Of course we do need. Now there are 2 stories that have been shown like an example in this chapter. Firstly, the first example is about the Asian Games construction workers. Now you know what, that in 1982, for the construction of Asian Games, the government of India had contracted some contractors. Those contractors had employed a large number of poor workers from our country. Now those workers were kept in a very poor condition. They were paid less than they were expected to be, like they were paid less than the minimum wages. At the same time, they were made work for more and more hours. Now a group of social scientists saw that and they petitioned the Supreme Court that making someone to do some work less than the minimum wages is acting like a beggar or forced labor, which is a violation of fundamental right against exploitation. Now Supreme Court heard that and gave its judgment to those contractors and to the government that they should pay all those workers the amount of money that they had to be given as their rightful wages. So firstly, this case is an example for this chapter. Secondly, we have the case of 𝓥𝓲𝓫𝓱𝓪𝓷. Now 𝓥𝓲𝓫𝓫𝓱𝓪 was 23 when he was arrested. First of all, who is he? Now he was a resident of a village in Assam, in Morigaon district of Assam. He was arrested for causing grievous injuries to the people, but he was found mentally too unstable. That is why he could not stand a trial. The court directed the police or the force to admit him in a mental psychiatrist hospital, like for the mental hospital. He was admitted to a mental hospital that was 𝓥𝓲𝓫𝓱𝓪𝓷 Hospital in Tejpur. Now after that, when he was found mentally stable, now when he became mentally stable, the doctors wrote twice to the Supreme Court that he could now stand a trial. In 1967 and in 1996 they wrote twice that now he was ready for a trial, but no one heard that. The letter got to no one, and that is why he was just there in that hospital, like in judicial custody. He was freed in 2005 when he was already 77. He spent his 54 years of his life in jail without any trial in the name of judicial custody. So these two are the examples of the importance of rights. We have seen that if these rights, like there were rights given to them, because why 𝓥𝓲𝓫𝓱𝓪 was freed? Because of National Human Rights Commission and NHRC, which made an investigation, and that is why he was freed. Now we can see that there are rights given to us that are on the paper, but they are not implemented. So this is the importance of rights. In both cases we saw that in the first case we saw that when there was a violation of some kind of right, of course there were some people coming up and that those workers could get their rightful wages. But in the second case we saw that the justice was not upheld because he did have to without any trial. You know what, that in our constitution it says the right to life and liberty. Our constitution has given the life as well as personal liberty, in which even the accused has a right of a fair and a speedy trial. So that is why you cannot put anyone in the prison without a trial. So that is how much the importance of the rights are. Secondly, the next topic we have here is Bill of Rights. So Bill of Rights. Now you know what, that we just saw these two examples of how the rights are important to anyone's life. Maybe it may be yours, mine, or anyone's. We all do need some basic rights to live off as of a citizen, as of a person. Now what happens that all there are countries like Bill of Rights. What exactly is a Bill of Rights? You know what, that basically Bill of Rights is the right set of rights which are given in the Constitution for the citizens. Now in those rights, of course there are some limitations as well, but at the same time a lot of rights are guaranteed to the citizens. These rights cannot be challenged even by the judiciary. You know what, that they can be violated. To see the protection of these fundamental rights, we do have the judiciary. Now what happens that in case of any violation of these fundamental rights, be it the executive, the legislature, or some kind of bureaucracy, no one can violate these fundamental rights. At the same time, we also have the judiciary for protecting these rights. So basically the Bill of Rights is what we know as fundamental rights in the Indian Constitution. It is known as Bill of Rights because firstly it was made in the USA. From the USA we adopted it. Now in the USA it is still known as the Bill of Rights. So Bill of Rights is basically a set of rights for the citizens in any constitution. Now all democracies must recognize these rights and implement these rights as well. It should not be that these rights are only written on the paper without actually being implemented on their ground reality. So it is a responsibility of every democracy to implement these rights as well, and at the same time of course have to be recognized as well. So that is what is meant by Bill of Rights that are. Now you know what, that if you look at the case of the South African government, we do know that there was a racial discrimination after the fall of apartheid government. What happened? Now a new constitution was made. Now the constitution of South Africa is known to be one of the most open-minded constitution that gives the most extended rights to the citizens. There you have many rights such as right to privacy, right to livelihood, right to adequate environment, right to internet as well. So there are a lot of rights given in the South African Constitution which are known to be one of the most extended rights to the citizens of their country. So basically that is what is Bill of Rights. Now next we have the topic fundamental rights in the Indian Constitution. So fundamental rights in the Indian Constitution. Now the freedom leaders. Now you know that before independence we did have a lot of freedom movement. Now in that freedom movement, the leaders, the Indian leaders, had seen the importance of having the fundamental rights or the rights for the citizens. That is why as far back as in 1928, the Motilal Nehru Committee had demanded the British government to give these rights to the Indian citizens, that they must be recognized as well. And it was of no questioning that when India became independent in 1947, there were no two opinions on the inclusion of fundamental rights in the Indian Constitution. Those rights were written in the Constitution that had to be guaranteed to the Indian citizens. Now these are known as fundamental rights. Indian Bill of Rights are known as fundamental rights. They are known as fundamental rights because in our Constitution we have a very special provision of these rights. So that makes them as a fundamental because we are specially adding these rights in the Indian Constitution. Apart from that, these are also different from the ordinary laws that we have, ordinary rights that we have. How are they different? Let us talk about them as well. Now ordinary law are when they are protected by the legislature and they are given by the legislature. At the same time, fundamental rights are given by the Constitution itself. So it is a responsibility of the Constitution to protect them. Secondly, all those ordinary laws, if they have to be changed, they will be changed by ordinary law making processes. But for changing anything in fundamental rights, you need constitutional amendment. You need to amend the Constitution itself. So that is what is the difference. Like for fundamental rights, there are some special cases that have been given. So fundamental rights in the Indian Constitution are also known to be one of the most extensive rights for the citizens, as there are a lot of fundamental rights. In part 3 of the Indian Constitution, the fundamental rights are given. Now we have fundamental rights from Article 14 to Article 32. Before that, we do have two articles that are different but that are related to fundamental rights. Now in fundamental rights, firstly we have right to equality from Article 14 to Article 18. Then we have right to freedom from Article 19 to Article 22. Then we have right against exploitation from Article 23 to Article 24. Then we have right to freedom of religion from Article 25 to Article 28. Then we have cultural and minorities rights, that is cultural and educational rights, that are from Article 29 to Article 30. Then we have right to constitutional remedies, that is Article 32. Now we will also talk about the Article 31 that was repealed. So these are the fundamental rights given in the Constitution of itself, and also by a special provision, like in a special part of the Constitution they have been given. So that is the fundamental rights of our country that cannot be challenged by anyone. However, these are not absolute rights. You must notice that these are not absolute rights. In case of emergency that have been that if it is imposed on the country, they can be violated. So in case of extreme situations, in case of emergency, they can be stopped. There can be limitations on these rights, and in case of some extreme conditions, there can be some limitations on these fundamental rights. Otherwise, they are very much important and very much powerful as well. That is what makes a citizen as powerful. They cannot be violated. Now the question is, who may violate them? Who may violate them to the other person, the right of a person? Now it may be violated by some private organization, by another person, by private organization, or by the government itself. However, they are protected. You can go to the Supreme Court or the High Court for seeking the protection of these rights. Now the next topic that we have got here is the right to equality. Now let us talk about our fundamental rights one by one as well. Firstly, we have the right to equality from Article 14 to Article 18. Of course, we are going to not talk about these articles specifically, but we will talk about them. Now, You must have seen some situations in your daily life, or even if they are given in your book as an example, you must know these situations. What happens is sometimes there is a story given us that there is a person named 𝓒𝓱𝓪𝓾𝓱𝓪 who is going to his village, and he is going there with his friend. Now he sat in a tea stall waiting for his tea. The shopkeeper knew 𝓒𝓱𝓪𝓾𝓱𝓪, but he did not know his friend. So he asked his name up for knowing his caste. Now the order was being served that the 𝓒𝓱𝓪𝓾𝓱𝓪 was given tea in a very beautiful mug, while at the same time the other person, his friend, was being given in an earthen pot that was looking ugly or somewhat very dirty as well, because this is known as a caste discrimination. He was discriminated on the basis of the caste. Secondly, we have another example. Then an order was being served that 4 news readers would not read the newspaper news on the screen anymore, just because they were above the age of 45. That was seemed to be reasonable because of their age, but at the same time there were 2 male figures above that age doing the same thing, reading the news on the screen. So why were they not asked to leave? This is known as a gender discrimination. So basically, we do see a lot of discrimination based on many things like the gender, the place of birth, their caste, their religion. So we do see a lot of discriminations. So to overcome that discrimination, to fight that discrimination, we have the right to equality, bestowing rights. Now in right to equality, firstly, no person shall be discriminated only on the basis of religion, race, caste, sex, or place of birth. Then we also have equal access to all the people, for all the people, to all the public places, entertainment places, bathing ghats, wells and bathrooms, all those public places there have been. So there will be equal access for all the people. If there is a public park, it would not be that only this religion or this caste is coming. It will be accessible for all the people equally. So that is the right to equality. Then we also have equality in public employment. It will not be that people are chosen just because of the that I said, only on the basis of religion, race, caste, sex, or place of birth. So no person shall be discriminated in public employment only on the basis of these grounds. Now you must notice the word only on. That says that only these grounds are. It could be that his qualification is more than you, that is why he is being chosen. So that does not mean you can go to the Supreme Court saying that this is the violation of right to equality. Of course it's not. If he is more qualified than you, he would be chosen. So that is only on the grounds of these certain areas there is a limitation. Then right to equality also, like we do see a lot of caste discrimination in our country. Even today there are, you must have seen. So that is why we also have Article 17 that says abolition of untouchability. Now, in abolition of untouchability that was a very poor, very bad practice against all those lower caste people by the upper caste people. So this practice of untouchability has been abolished by the Constitution of India in the Fundamental Rights by the Article 70. Then also, the government cannot give some kind of title to any person except in academic or military merit. Like if he is so good, if he has achieved something if that particular person has achieved something in military field or the academic field. Otherwise, that person would not be given any special titles by the government of India. So these are the provisions of the right to equality. Now, when we say that equality, you must have read the preamble of our Constitution. It says equality, equality of opportunity and of status, and to promote them among all. Now, what does the equality of status and of opportunity mean? Of course, equality of opportunity here means that every person must be given the equal opportunity to do something, like in public employment, in some kind of employment. That actually means it. But can we really expect that from social inequalities? How can we expect it? That is why the Constitution has said in this right that if the provisions are being made to bring the socially and educationally backward classes to the backward classes of the society, such as the children, the women, or some scheduled castes or scheduled tribes, those who are weaker sections of the society, then it is reasonable. The Article 16 itself says, Article 16 Clause 4 says that if the reservation is being made for the country, you do know that what are reservations, so that is reasonable. That would not be a violation of this right. Because a lot of people come and say that in right to equality every person must be given equality, but how can you expect equality when they are below the line? So to make them up to the line, we need some kind of assurance to them. That is why we have given reservations and made special schemes for those people who are weaker sections of the society. A lot of people argue about that as well, but that is reasonable. Now the next fundamental right that we have got here is right to freedom. So right to freedom, now equality and freedom, now or liberty it could be said, these are very much important as the rights of the citizens, because without one you cannot expect other. You cannot expect equality without the freedom or liberty, and you cannot expect freedom without equality, of course. So freedom, what does freedom means or liberty means? Liberty actually means the freedom of expression and action and press as well. So the freedom to do anything, some kind of expression, some kind of action, it could be some kind of belief, it could be, that is known as a liberty. But at the same time, freedom does not mean, liberty does not mean that you are doing anything disregarding the freedom of the other person. So if you are like using your freedom, your liberty, you may not violate the rights of the other as well. It should not be that you have been given the freedom of everything. That should not mean that till late night you're just playing on the music, disturbing all the neighbors. No, it should not be like that. It should be in respect with the rights of the other people without violating their rights. So that is what is the right to freedom gives to us. Now in the right to freedom, that is the second right of our fundamental rights, we have from Article 19 to Article 22, in which there are a lot of provisions, like right to life we have, with personal liberty, we have the right to education as well. So we have freedom, we have a lot of freedom to do anything, like you have seen in our country there is press, media, and there are a lot of things. So freedom basically means to do something without disregarding, like regarding the rights of the other people as well. So that is what is the right to freedom says. Now the next thing we have got here is right to life and personal liberty. So right to life and personal liberty. Now first and foremost right of any person is the right to life that has been given under the right to freedom and by the Article 21 of our Constitution. Now this right to life says that no person shall be denied of his or her life except the procedures laid by the law. That is, if you are wrong according to the law, or if you have done something against the law, then of course your life may be in danger, but otherwise your life is yours. Like you have the right to life, no one can deny that fact. Then another thing is that if we have the life, then what's the use of it if we don't have the personal liberty? So that is why personal liberty is also given in our Constitution. Now this says that if you are arrested by the police, then of course you must be told the reason for your arrest. If you are detained, then of course you must be told the reason for your detention as well. So that is why if you're being arrested, you can definitely ask the reason behind it. Then after, it is the responsibility of the police to show you or present you before the nearest magistrate within 24 hours. That is, after that, magistrate who is not a part of the police would decide whether the arrest is justified or not. So that is your personal liberty that you are having. Apart from that, by different judgments of the Supreme Court, the scope of this right has been expanded. That means now under the right to life and personal liberty under Article 21, you have a lot of rights, such as right to livelihood, because for any person to live off, what he needs is that some adequate amount of work, some adequate amount of livelihood he needs, some adequate amount of occupation he does need. So that is why right to livelihood, right to adequate environment, right to privacy, we have been given these rights under the Article 21, that is the right to life and personal liberty, which also shows after many judgments of the Supreme Court has declared the personal dignity, the concept of personal dignity as well. So that is why we need to live, we do have the right to life with personal dignity. That is without the basic needs of life, we cannot live as with our dignity. So that is why we have a very important, the first and foremost right here, Article 21, that is the right to life and the personal liberty. Then we have the next right, that is preventive detention. So preventive detention, now provisions for this detention has also been made in our constitution. Now what happens ordinarily, what happens if you are being arrested, you would definitely ask, someone has committed some kind of offense and the police is arresting that person. But in the case of preventive detention, the police or the government may arrest any person, whether even if he or she has not committed any crime, because of apprehension that person is likely to commit some kind of crime. So if that person is seen to be as a future kind of criminal, that he or she may commit crime or an offense to the law in the future, that is likely to do so, and the government can definitely, or the police, the government can definitely put that person in detention or in arrest without a trial, without any further notice, without the reason being told. So that is why that is known as preventive detention, the detention for the prevention of the crimes or the offenses. So that is the preventive detention. Now what happens, this preventive detention cannot be more than 3 months. If a person is detained, then of course it cannot be more than 3 months. Then after 3 months, an advisory board will say whether it was justified or not, whether it is okay to keep him for more time or not. So it would be in the hands of an advisory board. Now this seems to be a very good law. Like if you have this right, of course you can try to control the crime rates of your country, and there will be less crime rates in our country. But what happens actually is that many times it has been seen that government misused this law. There are many critics out there who say that this law has been misused by the government many a time, and that is why we need to do some kind of they show their dissatisfaction. There is a very hot tension between the right to life and personal liberty and the provisions for the preventive detention. So that is why there are, even there used to be some members of Constituent Assembly themselves who showed their dissatisfaction with the limitations of the fundamental right, not just this freedom but other freedoms as well. We will talk about them slowly and then get to know those facts as well. Now the next topic here is other freedoms. So other freedoms. Now you know what, that Article 19 is a very big article. Like you have many clauses in that. The Article 19 is about protection of all the citizens and right to all the citizens for the freedom of, firstly, freedom of expression and speech, secondly, assemble peacefully, thirdly, to form associations or unions, fourth, we have that to reside, to move to any part of the country, to go to any territory of the country. Fifth, we have to reside and settle in any part of the country. Sixth, to profess any profession or to carry on any trade and occupation. Now you might think that, wow, it's so good, like we have all the freedoms, but it's a pity that we don't have everything, because there are some limitations on these freedoms. First of all, you know what, that freedom of expression and speech says that, yeah, you have opened a channel, a newspaper, a news channel or anything, and you can talk anything, but that should be in order. If it it goes against the public order, morality, then of course it can be banned. So there are limitations on the grounds of public order, law and order, morality, and that can be acted as a limitation on that particular rights. Then of course you have to assemble peacefully. That means you can't just go on with swords, with knives, and that is a good thing. But apart from that, that administration takes profit of it as well. Sometimes the administration may impose a law that is of the Indian Penal Code, and there could not be a crowd of more than 5 people. So that can be caused by the administration of that particular area. Then you can definitely move in any part or the territory of India, but there are some areas which due to the public safety have been banned to be visited by the common people, such as the border areas we have. You cannot go there because definitely it's dangerous. So we do have some limitations on the grounds of public health, public order, morality on many of these rights. So of course we have been given other freedoms as well, like the Article 21A is about the right to education. Article 21 is about the right to life and freedom, right to life and personal liberty. Then we have Article 21A saying the right to education, that every citizen must be granted the education between the age of 6 and 14 years by the government. It is a responsibility of the government to do so now. Then we have other freedoms, such as a lot of freedoms are there. Rights are given to a lot of people as well, and even to an accused person, these rights are given. So let us talk about these rights as well, that are rights of accused. So rights of an accused. Now many times what happens, you see a case in your TV, maybe a news channel or maybe in your phone. They see that a person is being convicted, like a person is being accused. That person is standing now in a trial. Now he is being in the court, presented in court. Then you think that if a case is against that person, then that person is guilty. That person is a convict. But it's not so. Until the judge decides, until the court decides of that person to be guilty, that person is only an accused person, not a convict or a guilty person. So that is why we have to call that person as an accused, not as a convict or a guilty person, because offenses are not clear whether they are made by him or not. So that is why it is known as accused person. Now that accused person also has some rights which have to be given to that person particularly. There are 3 major rights given to an accused, that are, first of all, no person can be trialed, no person can be accused for a crime for more than once. Like you cannot punish a person for like stealing something, then again after 10 years they come that you stole something 10 years ago, now I'm punishing you again. That cannot be a case. That would be a case of jeopardy. So of course no person can be punished, no citizen can be punished for a crime, for one offense twice. Then after we have the second right given to him, that is, no law can be made as an offense from a back date. Suppose a person did something. Now after 10 years you are making that thing as unlawful, as a kind of you could say offense. Then you cannot punish that person because it's a back date. Only after the announcement of that particular thing would it be counted as an offense. So of course for backdate it is not possible because it's like against the morality. And thirdly, no person shall be asked to give evidence against himself or herself. You cannot force a person, of course, who would want to give evidence against themselves. So that is why these are the rights of an accused person, so that it would be his right. Now again, in Article 21 we have, under right to life we have a lot of rights. In one of them is right against solitary confinement. You cannot confine a person with solitary, that is alone. So that is why these are the rights of an accused person. Now next, moving on, we have a topic that is right against exploitation. Now this is the third fundamental right that we have got as being the citizen of India. So first was right to equality, second was the right to freedom, now third we have right against exploitation, where two articles have been stated. Now you know what, that in our country there are millions of background people, like backdrop people who are very much poor, who are very much underprivileged in our country. There are a lot of children, they may be old aged people, maybe women or men. They can be poor workers, construction site workers, maybe from some kind of because of caste discrimination, because of religion discrimination. It must maybe because of their conditions. So there are a lot of underprivileged people in our country. We have to accept that. So that is why, to protect their rights, to protect their lives, we have, like the constitution makers have made provisions for their rights as well. Now one way to exploit those people is that by making them do work such as begar, or that could also be forced labor without any wage. Secondly, we also have bonded labor. Now what happens that this begar or forced labor generally was practiced by big money lenders, land owners, by big masters, landlords and lords, you know, those people. So these were being practiced by those people. So that is why our fundamental rights, the fundamental right against exploitation says that there shall be no kind of bonded labor, begar or forced labor. Bonded labor was also being practiced. Still in India, we do see some cases of these particular practices such as bonded labor. In bonded labor, you do know what it is. So the practice of begar, forced labor, bonded labor is now a kind of crime, and it is an offense. Then of course we also have many acts following that, such as the Factories Act, the Minimum Wages Act, and a lot of acts. Then we also have right against the right for child labor. That is, child labor must not be practiced in our country. The children cannot be employed in hazardous factory who are under the age of 14, which is being supported by the right to life by Article 21A as well, which says about right to education. So children who are under the age of 14 cannot be employed, shall not be employed in hazardous factories. Now hazardous factories, you do know what these are. Hazardous work could be some match work, firecrackers work, then we have chemical works, coal minings. Their children cannot be employed. So the right to exploitation is this. Then we also have another provision, that is the trafficking of the people. The buying and selling of human beings is commenced as a crime in the Constitution of India. So of course no person can be sold or bought by another human being or another human fellow, because it is against the concept of morality and a lot of things. So of course these have been made as a crime in the Constitution, that these rights are guaranteed to every people. No person can be made to work as a bonded labor. No person can be in the business of human trafficking, and the right against child labor. So these are the provisions under the right against exploitation. Then moving on, we have the next right, that is right to freedom of religion. So right to freedom of religion. Now after right against exploitation, we have the fourth fundamental right, that is right to freedom of religion. Now you know what, that India is a secular country. You must have heard this phrase a lot of times. Basically a secular country means that which adopts which kind of tolerates all kind of religions. It's not that there is any official religion of that country that we do follow in India. In India, historically, we have a lot of cases of rulers, of emperors who chose a religion for their country. That is, if a resident was not of that religion, either he was persecuted or made to be converted into that particular religion, forced to be converted in that religion, or because of that situation he did it by himself. So that is why in our constitution, in the Indian constitution, we have the right to freedom of religion. Every person has the right to choose a religion of his or her choice. That is, to profess, propagate and practice any religion in our country. It is the main line. So we have a lot of rights for the freedom of religion as well. Let us talk about them one by one. Firstly, we have freedom of faith and worship. So freedom of faith and worship. Now the Constitution of India gives us the right, all the citizens of the right, to profess, propagate and to practice any religion. That is, religious freedom means that you have the right to follow any religion of your choice. Also, it gives the right to conscience. That means you may choose or may choose not to follow any particular religion. It is your choice of your conscience. Then of course you can follow any religion of your choice, and also the religious groups have been given the right to manage their religious matters as well. The government does not interfere in that. However, government has the right for eradicating social evils. That government can interfere in the private matters of these religious communities or groups, such as in the case of human sacrifice, the practice of sati, the practice of untouchability. The government had interfered in the matters of the religion. So the government can interfere in the matters of the religion, of any particular religion, as far as it is for eradicating social evils. Then of course every person has a right to propagate one's religion. That means to promote their religion. They are promoting religion and are asking people to convert themselves for the religious conversions. However, there are many critics who are against the conversions of religions, and they say that it is not a right thing to do so. Still, they have to see that the Indian Constitution is only promoting the propagation. That is, you can only promote your religion, that is, talk about it, promote its information. The forcible conversions are against the procedures laid by the law. You cannot force any person to be converted in your religion. You can only promote your religion by making some good benefits. Still, you cannot make the other person to convert in your religion by forcible actions, by forcefully actions. So that is the freedom of faith and worship that we have got. Like, we do have a lot of freedom of faith because you are following your religion without being interfered, without being bothered. Then of course there are a lot of controversies going on as well, because a lot of times the government and the religious leaders or the religious communities are against each other, saying that the religious communities say that the government is interfering in their matters, which is a violation of the right of freedom to religion. So that is why there are a lot of controversies related to that. Still, it is considered to be a good right for us. Then the next right here we have is equality of all religion. Now, you do know that India is a home to a lot of religions. Like, there are a lot of religions, like the Hinduism, we have the Islam, the Sikh religion, then we have Buddhism, Jainism as well. So we do have a lot of religions in our country. So it is the responsibility of us that we should have equality for all the religions. That is why in India it is laid, even in the article 15 of the right to equality, we do see that the discrimination only on the basis of religion, caste, race or sex or place of birth is prohibited. So of course there can be no discrimination on the basis of religion. So that is why that you don't need a particular religion. India does not have a national religion. So for being a prime minister or the president or the judge or any public officer, you don't need to belong to any particular religion. You can be from any religion. Then after, we don't promote any religion at all. At particular, we don't. The government does not promote any religion and shall not promote any particular religion. Thereafter, in the schools or in colleges, universities, promotion of any particular religion is also prohibited. Then we have we don't allow negatively, we do a lot of things. So of course that is the equality of all the religions. Many people think that it is wrong, but still India is a secular country. Secularism is a very important concept in itself that we still have a chapter in this class. In political science, we do have a chapter related to that. So of course, secular country, being a secular country means a lot for India, which has a lot of diversity. So let us talk about the next right that is related to it: cultural and educational rights. So cultural and educational rights. Now this has to be the fifth right that we have got, fifth fundamental right of ours. You know what, that when we talk about the diversity, what do you think? You do have a lot of image of India's diversities. We have a lot of different type of people and there is a lot of diversity in many matters, just not in religion. So that is why we can say that in a region there is a majority and a minority. So what about the culture, the traditions, the rights of the minorities? Are the rights being given to the minorities? So that is why this particular fundamental right is for those minority people. You know what, that this right gives right to the minorities people, not just on the basis of religion, but it could be linguistic or cultural, that they have the right to preserve their culture. Also, they have the right to set up their own educational institutions from which they can preserve their culture, their language and their traditions as well. The government aiding that particular educational institution cannot discriminate against that just because it is being managed by a minority group. So a minority here means that a particular section of people in a minority on the basis of religion, linguistic, cultural, in being outnumbered in some particular territory of India, in some particular space of India. So that is why if they are being outnumbered in some particular area, it is known as a minority of that area. Now there are a lot of arguments that we all are a majority and a minority in some case or another. You may be a majority in your language, but are you a majority in your, it could be anything, the physical features, the cultural features, the historical features, your name feature, your initial feature. You have to be a minority. You must be a minority in some case or another. So every person is a majority in anything. Suppose there is a person of a very good background, of a very good caste, so he will be a majority. But what about the gender? That person may be a minority. So of course that is about the majority and minority thing. So that is why we have cultural and educational rights, especially these are known as the rights to minorities, because there you have the right for the minority people. Then we have the next right, that is right to constitutional remedies. So right to constitutional remedies. Now this right is very much important. You do know that till now we have seen, yes, in India we have a lot of impressive rights. Fundamental rights have been given on a very good scale to the Indian citizens. But what about the implementation? They should be implemented as well. What if they are violated by other people or the government? We have assurance for that? Of course we do have. And that is the Article 32, the last fundamental right of our country, our Indian Constitution, that is right to constitutional remedies, which gives the right to every citizen of India to go directly to the Supreme Court or to the High Court when his or her fundamental right is being violated. In that case, the Supreme Court or the High Court can give or issue some writs. Now there are some writs under the hands of the Supreme Court or the High Court. You know what, that under the Article 32 it is only the Supreme Court, but under the Article 226, that is not a part of fundamental right, they have been given to High Courts as well. Now the first writ is habeas corpus. Now under habeas corpus, the court can ask for any arrested person to be shown before it to the police, and it can also order the police to free that person in case it finds that that person is not of a guilty conscience, is not justified for arrestment. Then we have secondly mandamus. Now mandamus writ is issued when a court sees a public officer not doing his legal duty and stepping on the rights of an individual. Thirdly, we have prohibition. Prohibition writ is issued by a court, by a higher court. It could be a Supreme Court or the High Court, to a lower court when it sees that that particular lower court has gone beyond its jurisdiction. Fourth, we have quo warranto. Quo warranto is issued when the apex court finds a person, a public officer holding a public office but is not entitled to it. And lastly, we have certiorari. Now under this writ, the higher authority, the higher court of course, asks the lower court to transfer any pending cases which it sees to be justified to be solved in its hands. So these 5 writs can be issued by the Supreme Court or the High Court for the protections of your fundamental rights. So that is, we do have protection, some kind of a surety to our fundamental rights, and by the Supreme Court, the highest court of our country. So that is the power of our fundamental rights. Now apart from these writs, we also have some commissions, some individual commissions, committees, groups working for the implementation of the fundamental rights. These could be National Commission for the Scheduled Caste, National Commission for the Minorities, for Women, National Human Rights Commission, that we'll talk later as well, and a lot of commission for child, women development as well. So let us talk about one of the very prominent commission, that is National Human Rights Commission or NHRC. So let us talk about this commission. It was founded in 1933 by the government of India. First you have to notice that. Now you know what, that the question is that you have the fundamental rights, you have the rights. The rights are okay, the rights are very impressive until and unless they are implemented on the ground reality. And to implement them ground reality, these commissions work, and one of them is National Human Rights Commission, set up in 1933. Now in this National Commission, you have a former Chief Justice of the Supreme Court or the Chief Justice of India, a Chief Justice of High Court, 2 senior judges from the Supreme Court, and 2 people who are very much experienced in this field and are worthy of being in this field. So it is a very high class kind of high educated people, high scholar people as well. Now what happens, this NHRC gives when it can work for the investigations of whether the rights are being followed by being implemented in the country as well. There are it can work by having some kind of letters, by some kind of requests by the victims, or by their own instinctions, by their own impulses. So they have done very good jobs in some cases, such as Gujarat riots cases, and we have a lot of cases they did some very good work. So they generally do the cases of custodial death, custodial rape. We have a lot of other offenses such as riots, and a lot of big cases are. Now however, these commissions are individual, that is, they are not governmental. So that means that they can only and give some suggestions. They don't have the right for persecution, like prosecution, not persecution, but they don't have the right for the prosecution process. That is, they are not the judge. They cannot go, they can only file petitions in the Supreme Court, but they cannot be the judge themselves. So that is the National Human Rights Commission, which works for the fundamental rights, for protecting the rights of the people in our country, and is a very big, at a large scale as well. Next, we have a very interesting topic, that is Directive Principle of State Policy, or what we call as DPSP. So DPSP. Now let us talk about these Directive Principles of State Policy. You know what, that when the Constitution was being made by the Constituent Assembly or the Constitution makers, they had seen that India would face problems in the future. Like there were at that time also, there were a lot of problems in the polity of our country. So that is why they needed to ensure something, that they should give some instructions for the future governments so that they would go on a right path and could do their work. At the same time, they did not want to limit these governments, the future governments, for doing same thing that was written in the Constitution. So that is why they wanted just some directions for them, and that they inserted Directive Principle of State Policy that are non-justiciable in nature. That is, they are not legally enforceable by the Constitution of India, so that if they are violated, if the state government or the central government is not following these policies, then of course you cannot go to the Supreme Court saying that these are violated, because they are non-justiciable in nature. So Directive Principle of State Policy are basically those principles that have been given as an instruction for the state government, for the government of our country, that they should follow in order of morality, in thing of public well-being, and a lot of things. So they are just kind of instructions for the well-being of the society. There are a lot of things that we'll discuss later as well. So basically that is Directive Principles of State Policy. Then the next question that arises here is, what do the DPSP contain, or the Directive Principles contain? Now you know what, that there are three provisions. There are mainly three things that are contained in the Directive Principles, that are first, some objectives and goals for the citizens of India that we as citizens should follow. Secondly, some instructions for the state government, for the government of our country, like they should also do something that is a kind of, that could be some kind of aspiration, some kind of good work as well. And thirdly, some rights that apart from fundamental rights we should enjoy, the citizens should enjoy. So of course these three are given in the Directive Principle of State Policy. Like the goals, we have to, of course, to follow our constitution, to make like there are many objectives to instruct the government as well, to make our kind of our country as a liquor free, that there should not be intoxication in our country. Also for enforcing these things, the government has also made some provisions, made some acts, such as the Factories Act, the Coal Mines Act. Then we have Fixed Wages Act, Fixed Minimum Wages Act. For promoting the cottage and small industries, we also have some provisions. For the upliftment of the scheduled castes and the scheduled tribes, we have reservation. And for banning some immoral things, we also have provisions. So for implementing these instructions in the Directive Principle of State Policy, the government of India has passed a lot of laws, a lot of acts, bills for implementing these things, and to make people follow it as well. And we also, as the citizens of India, should follow. Like we are the citizens of India, so we must have the pride for being in it. Then apart from this, we also have another thing that are known as fundamental duties. Now, fundamental duties are under the Article 51A, and originally they were inserted at the time of when the Constitution was made. They were not there, but it was added by the 42nd Constitutional Amendment Act in 1976. Originally, there were 10 fundamental duties. These are the duties that we as citizens should follow, should do. Then after that, by the 86th Constitutional Amendment Act of 2002, another one was added. So to promote, to have pride, to respect the national flag, national anthem, to have good temperament to all the other human fellows. Then after, to provide good education and care for the children till the age of 6. Then we have a lot of provisions, that lot of fundamental duties that we as citizens should do, should perform. These duties are our responsibilities. So of course we have directive principles, state policy, then we have also fundamental duties that we'll talk about them in later chapters as well. So that is what the directive principles, state policy contain in our country. Now, the last but not the least topic here we have is relationship between fundamental rights and directive principles. So relationship between the fundamental rights and the directive principles. Now this used to be a very big and a very controversial topic as well. You know what that fundamental rights, what are they? They are the rights for the individuals. At the same time, the directive principles, state policy are for the well-being of the whole society. So what if there is a controversy? Who claims more? Like who overpowers the others? So we have to talk about that as well. Now what happened, that there was always a question that to protect, to promote the directive principles, what if it violates the fundamental rights? There was always this controversy. And when government tried to abolish the zamindari system by enacting a law, there were many people who came up and said that this was against the right to property. Now right to property, you must know that this was the Article 31, in which there was Article 31A, B and C. But this was repealed. Of course it was repealed by the Constitutional Amendment Act. Still, when it was not repealed, this was the case. So all the people were saying in courts, what happened? The government said that to follow, to promote, to enact the instructions given in the directive principles, state policy, we need to violate the fundamental rights. While the people were saying that, and the court was also saying that the parliament could not make laws against the fundamental rights, while the government was saying that parliament could make it. So there was this controversy, and of course it was something like that which can be more powerful. Then this was finally solved by a very famous case of 𝓥𝓲𝓪𝓾𝓱𝓪𝓷 case in 1973. Now in 1973, in 𝓥𝓲𝓪𝓾𝓱𝓪𝓷 case, we will also talk about it in the last chapter of this book, but still we have got some clues about it. So what happened? The judges, the Supreme Court declared that there would be a basic structure of the Constitution, or what we call the basic feature of the Constitution. Now in that basic structure, there are some rights, there are some provisions that can never ever be challenged by the government or the parliament, in which there is something like independent judiciary, some fundamental rights as well. So of course we do have, by the 𝓥𝓲𝓪𝓾𝓱𝓪𝓷 case, we have now seen that directive principles are not that much powerful as much the fundamental rights are. So fundamental rights are about, like you can say that if there is controversy about the right to information and the right to privacy, so of course right to privacy would be more powerful because it is the individual's right. So of course this is the relationship between the directive principles and the fundamental rights, and that is all we have discussed in this chapter. Now in this chapter you have got the answers of the questions that I asked in the earliest part. Those were the various fundamental rights. We have talked about them. The role of judiciary, we also have talked about them, by the right to constitutional remedies. Then also the relationship between the judiciary, between the directive principles and the fundamental rights. So of course we have seen it, and we also have seen that these fundamental rights are very much important, especially the last one, the right to constitutional remedies. Dr. B.R. Ambedkar once said that these are the spirit of the right to constitutional remedy, is the spirit of the all fundamental rights. So of course without it these were legally not enforceable, but now these fundamental rights are legally enforceable, that if these are violated you can definitely go to the courts, to the Supreme Court as well. So this is all I have covered. Now I've talked all about the topics, all the fundamental rights, all one by one. So I've covered all the topics and subtopics, and the next chapters of this book will be covered in further upcoming videos. So stay tuned for the upcoming videos. Thank you very much.